The power conferences unite in support of the ACC versus AG Moody in Leon County. And in North Carolina, we go for an appeal.
The ACC lawsuits are always in the news, so we're back on the big mountain to keep you updated.
Hey, good to have you back here on the mountain. I'm JY. This is my good friend Steve. Steve, we have two things we need to talk about here with FSU. I dropped a breaking news. I soloed it because I just had to on Friday regarding what came out in Leon County in the Big Ten, the Big 12, and the SEC coming to the support of the ACC and ESPN in terms of the writ of Mandamus that AG Moody put forth. But before we get to that, I just want to lay out real quickly the appeal process in North Carolina. We haven't heard a lot about that, but it was docketed here. I believe it was last week. I don't know the exact date. But it was docketed with the Supreme Court in North Carolina. And I want to give a thanks to David McKenzie. He actually laid out the timeline of how this was going to proceed. So I want to give that to our viewers as well. It's going to take 2-3 months here to just to lay out all these briefs and everything that they have. So now that it's been docketed, FSU can file their main brief. That'll probably be done. It needs to be done by about July 1st. So they'll have about a month here to file their main brief. Then the ACC, of course, can do a responsive brief. They have about 15 days to do that. So 30 days. So we have about early August there. And then the FSU can reply to the reply, and that would be about mid-August. So till we get through all of these briefs and filings and everything like that, you're probably talking mid-August, give or take. And then at that point, we have no idea when any sort of oral arguments or any sort of decision on merits is going to be made. It certainly won't be before the middle of August because they're only going to get their briefs in by the middle of August. So we're not going to be hearing about a whole lot in North Carolina there. I mean, we'll do some reporting when the briefs, kind of come out on that. But yeah, things are going to go a little slowly here, at least from news in North Carolina. But things aren't going very slowly in Leon County. And we want to talk about next is this writ of Mandamus and some of the big highlights that came out of and news that came out of late last week. We also know that Judge Cooper is going to be moving forward with another hearing here shortly as well. But I don't want people to confuse these two things. They are two completely separate lawsuits. The Judge Cooper issue is the ACC versus FSU. That's what's happening over there. What we're going to be talking about next really doesn't have anything to do with that at all. It's a standalone issue where AG Moody has filed this writ of Mandamus that's really imploring or instructing, mandating, I guess would be the correct word, mandating the ACC, a non-resident entity, to give the media rights agreement that's completely unredacted. So the new headlines last week, as I said, the P3 outside of the ACC have now thrown in their support to ESPN and to the ACC. I've seen some people on X again saying, they can put this forward. It can just be redacted as trade secrets and da-da-da-da-da. They can, and that's what's going to happen in these cases. Like, people are going to see some of these agreements with redactions and protections and all that kind of stuff. But that's not what she's asking for. She's asking for the entire document as is, every I, every T crossed, done, no redactions. So don't get confused on this. She wants the whole document as is. So let's get into some of these details to the filing that the Big Ten and the Big 12 and the SEC filed in Leon County. All three conferences, they kind of start with all three, kind of get a little summary page about who they are and how they view this. All three conferences state that the media rights agreements with their media partners contain highly confidential and proprietary information. They are strictly guarded, and only a small handful of people are involved in these negotiations. They also say they are restricted to agents of the people that negotiated these agreements or have a business need to know the contents of the final agreements. The agreement here is that the argument here is that these agreements are highly confidential trade secrets, which, if disclosed, could cause irreparable harm to both the media partner and to the conference. The Florida Public Records Act is not without limitations. One of those limitations is trade secrets. The legislature recognized that disclosure of trade secrets would negatively impact business interest and cause damage to the marketplace. Trade secrets are defined in two different areas of the Florida statutes, and I'm not going to get into the details there and bore you with that, but they're found in two places, and the conference's media rights meet those two tests, according to this filing. The arguments then are broken down into three main sections. The first, the conference's media agreements are highly confidential. While the compensation portion is one of the negotiated terms, it is far from the only one. They then list 14 different non-monetary but heavily guarded negotiated provisions. Number 2, disclosure of media agreements would be competitively detrimental. If these were released to the public, the conferences would be at a competitive disadvantage. They go on to state three main reasons why these could cause harm during current and future negotiations. And then number 3, the conference's media agreements are trade secrets that are entitled to the protection under the public record laws. A media agreement's competitive sensitivity require that it be protected as a trade secret or some other similar exception. Courts in Florida and across the country have recognized the competitive sensitivity of these agreements. Again, they state these meet the two tests that Florida has in place. In conclusion, they respectfully submit that the AG request for a mandamus be denied and that the complaint be dismissed. Steve, what did you think when you saw the headline that the other power conferences were putting forth this? I think it was an amicus curiae or something like that.
Yeah.
I may not
They're
say
asking
that right,
permission to file an amicus brief.
Yes,
part of it.
They're asking to file an amicus brief. What did you think when you saw that?
Not surprised one bit.
Okay.
All of them have similar interests. We've talked before. A lot of the things that Florida State is trying to do, and now AG Moody is trying to do in Florida, these things could have far-reaching consequences. We've talked about this. There are multiple public universities in the state of Florida, and those public universities participate in multiple different athletic conferences, which are multi-billion-dollar businesses. So it did not surprise me at all. Think about it this way: if the precedent gets set, if AG Moody's request is upheld and enforced by a court, by a judge, which could happen, to have the ACC contract released, then someone else could do the same thing and ask for the SEC's contract with ESPN Disney,
right?
The Big 12 contract, and Big 10 is looking to move down into Florida. So it doesn't surprise me at all. They all have similar interests, and they all want to protect these rights. So I really was not surprised at all. I still don't know. I have no. The thing is it doesn't matter what the conferences think. It doesn't matter what AG Moody thinks. It doesn't matter what we think. It really is going to come down to this judge. If he decides that the trade secrets, protecting the trade secrets is more important than basically the public records law, public disclosure law, the not the fact that they have that law, but the importance of the public knowing what is in those agreements and how it affects public universities, public tax dollars. So a judge is going to have to decide that one way or the other. Doesn't really surprise me that they got involved. They have similar interests. I have no idea if AG Moody's her writ is going to be granted and enforced by a judge. It seems like I use Doug Rohan as my kind of touchstone, and he said something like AG Moody probably should just release a statement and say my bad and withdraw it. So to me, if that's his impression of it, then it's probably doesn't have a lot of chance of succeeding, or maybe it's just not a good idea in general.
Yeah.
But again, none of us know How is a judge going to look at it? Is a judge, because this could be a major game changer and have far-reaching consequences. So it's incredibly important whichever way it goes, because it could affect those other schools, other conferences, basically the entire industry, college football industry, along with sports media industry. So it's a massive thing, but we have no idea which way it's going to go. So not surprised at all, but just still curious on what happens. This was her first attempt. Is she going to be a power player in this, or is she just a two-bit politician who's trying to put her name out there and get some love for, during election season? I don't know. And really, it's going to come down to whatever the judge decides. Because if the judge slaps her away and says, "No, we're not going to do this. This is stupid," then she looks like a fool. But if she is successful here, she all of a sudden puts herself on the map as a big-time power player in this case. And you're right, this is not directly connected to the Florida State case, but in reality, it's got its tentacles through all of these cases, and really, it can be precedent setting for the entire industry.
Well, and I would say, not to disagree with you, but I would say that if she fails in this, okay, she failed, but she can at least tell her public that she tried to do something. I tried to get us, our state, this agreement. The court said I wasn't allowed to have it for the whatever reasons they're going to decide upon. I firmly believe that they're going to decide that she's not going to get this sucker. This is going to either be, their conclusion was to be denied and the complaint to be dismissed. I think that's personally what I think is going to happen. Or a betting podcast. And so my bet, I would put all my money on the fact that it's going to be dismissed. But with that being said, even if it is, we've talked a lot, and you talked with Doug Rohan on our last episode about could we see more interaction and more engagement with both A.G. Moody, with other state politicians, Governor DeSantis, whatever the case may be. Are we going to see more of that in the future? This might be step one in several steps. We don't know that, but she can at least now say she's trying, she's engaged. It's obviously a hot topic in Florida. She has a lot of other things going on, but hey, she's got to engage them, and clearly she's doing that here. Win or lose, hey, they say, what is it? No press is bad press, or whatever the hell they call it. They say there. And the other thing I would just say, you mentioned, they're going to have to judge who is harmed greater. Is the public harmed greater by not being able to see these agreements, or are these entities harmed greater because of the trade? If we release them, they now don't have these trade secrets. They're open to the public, and things that I already went over in the arguments that the SEC, Big 10, and Big 12 kind of made here. Where does the scale weigh? I've been on Twitter a couple times, or X, and I've been like, clearly to me, the greater harm is with these trade secrets. And I'm not saying the entire document. Please don't misunderstand what I'm saying. As I said in the beginning, you're first of all, the courts in Judge Cooper's court, both sides and the judge are going to see what they need to see. So it really doesn't matter if I see it. I'm not here to make a judgment. He's there to make a judgment. So, people get all crazy about all this kind of stuff. Would it be fun to see? Yeah, I'd like to see it, but I don't need to see it.
Yeah.
Am I wrong?
I don't know. No, I don't think you're necessarily wrong. However, I think this is a total 50-50. I think anybody who thinks they know it's which way. And I'm not saying this about you, but there's a lot of people. There's a lot of people that say this is not going to happen, and then there's other the people, the Florida Sunshine Law people that have to remind us every video that Florida has sunshine laws, that think this is obviously going to be given. I think that is just people kind of aligning with their personal held beliefs kind of thing. I think it's 50-50. I have no idea which way it's going to go. I think this is going to be a complete precedent setting. There is a lot of precedent in the state of Florida for these public record laws. Almost always going for the public. So I think that's one part. But on the other hand, it does meet the criteria, like the other conferences are saying, of trade secrets. And I don't know that it's a matter of which one is harmed more. I think it's more where a judge is going to have to decide what's more important.
Yeah.
Not necessarily which one is harmed more. They might just decide it's more important in this time. With politics, budget shortfalls. We're seeing this in the state of Pennsylvania with Penn State. With all of this that's going on with politics and budgets and schools, higher educations, universities losing money hand over fist, athletic departments making so much money, this could be a time where a judge says, you know what? We're going to put this all out in the open. These are public institutions. We need to see how this money is being made because this is affecting a public institution paid for by tax dollars. So I could see it that way, or I could see it the other way where the judge saying there's no need for this. We can protect the trade secrets. Right. A judge in the particular case can see and open up. And I think it's 50-50. I don't have a one way or the other.
Okay, so I want to hear from our viewers. Steve says 50-50. I'm going to go 90-10. That it's dismissed. It's not happening. I actually think it's greater than that, but I'll say 90-10, make it nice and even. So I want to hear from our viewers. Put comments in the comment section. We always enjoy that. But I want to hear from our viewers. Where are you at with this? Are you 50-50? Are you 70-30? Where are you at? Are you 100-0 maybe? I would love to hear if somebody's 100% confident one way or the other. So throw that down in the comments. Last thing I just want to say, Steve, there was an email that got popped up onto the Leon County site late. I think it was the 31st, which was Friday. And there was some speculation. I don't know if it's speculation or it's, you can't access it. I looked at it today. I know we're not going to drop this until Tuesday. We're recording on a Sunday, so I'm guessing by this time we're going to get comments. Whoa, it said this. Okay, we're recording on a Sunday, so please, we didn't have access. I looked right before we came on this sucker, and I don't know what the email is. I think there's thoughts that it could be AG Moody emailing the judge about something with the case. Yeah. So it'll be really interesting to see if
maybe it's, as Doug Rohan suggested, maybe it just says, my bad, I withdraw.
Okay. Is that where that came from?
That's pretty much what he said. He said it should be her saying my bad and withdrawing. That's what I took from his tweets.
Yeah, okay.
I know Doug is fully invested in Florida State baseball right now, but that's what I took from his tweet. It should be her saying, my bad, never mind.
Okay, all right. Well, that'd be interesting.
Yeah.
Some other emoji like, one of those emojis like, I tried.
Yeah.
But anyway, hey, we thank you guys for watching this. I know we have a lot of FSU fans and ACC fans that have found our channel, subscribed to our channel. We're staying on all this FSU stuff. We've had Doug on several times. We had David McKenzie on, and so we're gonna stay on this. We find it really interesting. As we've always said, we're not lawyers. But we do enjoy following this very closely. As Steve has said, he's the Big Ten guy here on the mountain. We absolutely believe that that FSU has a seat at the Big Ten table waiting for them once all of this gets figured out, which is one of the reasons we follow this. I follow it because I actually think it's entertaining.
Yeah, really interesting.
And I couldn't care less because I'm not a Seminole fan and I'm not an ACC fan. So, although I do get caught an ACC homer at times, but that's okay. I got, as Doug said the last time he was on, we got thick skin. So it's okay.
I think this case is going to be the most, not just interesting, but basically the precedent setting for what happens in the next 10 years of college football expansion, of realignment, all that stuff. This case right here is going to set the precedent and be the most important case.
FSU took the jump, that's for sure. Yeah. Clemson's behind them, but FSU took the jump for sure. They're a Seminole on the warpath, no doubt about it. So, hey, we thank you guys for watching. Be sure you give this one a like. Subscribe if you like our content. If you haven't already. We'll see you next time on the Big Mountain.